Good morning, everyone. I hope everyone's doing well today. I'm Heather Hughes, and I appreciate you taking the time to join us today for our Partnering for Success webinar series. Today, we will be discussing tackling personnel policies. We will be recording today's webinar, and we will be distributing a link to it to all registered participants. As we progress through the presentation, please feel free to ask questions. You can put your questions in the chat and we will interrupt the process as we go along to get those questions answered. Our presenter today is John Grubbs with MTAS. John has served in human resources, operations management, and consulting roles for more than 35 years in the public and private sectors. He has served multiple organizations as HR director, including two Tennessee cities, White House and Portland. He's been with MTAS since 2015 and currently serves as the HR consultant for Middle Tennessee towns and cities. He holds a master's in HR management from the University of Connecticut and is currently a master's candidate in industrial organizational psychology at Austin Peay State University. He also holds senior level certifications from the HR Certification Institute, Society for Human Resource Management, and the Public Sector Resources Association. So, without further ado, I give you John Grubbs.
Good morning, everyone. Thanks for letting me hang out with you and talk about tackling personnel policies. I'm going to go ahead and share my screen here in a moment, but before we get started, again, I want to reiterate what Heather said. Put questions if you have any in the chat. And if we need to stop, I'm going to try to have some kind of natural pauses in here where we can address some questions. But if there's something very urgent, just let Heather know and we'll get to it. That said, let me go ahead and share my screen. And while I'm sharing, I'm going to go ahead and stop my video, but I promise you I'm not going anywhere. All right, so tackling personnel policies. Now, this little webinar today is intended to address certain issues, certain topics, primarily related to cities, because that's my focus area. However, some of the content will cut across a variety of public sector agencies. Some will not apply, and you'll recognize those. All right, so today, the four primary areas that we would like to discuss: the purpose of the review. Why do we review personnel policies? Why is it important? But also, what do we stand to gain from it or lose from not doing it? The materials to gather, how to unpack and sort those materials, and some steps to consider when you're going through the process. So with that said, the first thing that I would like to do, I would like to get a sense from you all, and we're going to have a poll here. And I'm interested in finding out how many years it's been since your last personnel policy revision has occurred. Heather, I think that might be the wrong poll. That's the one about charters.
I think I have the years in review. Let's go back.
Okay.
Apologies.
No worries. Yeah, there we go. So if you would, weigh in on the poll. If it's been 1 year or less, you've recently updated your personnel policy. It's been 2 or more years since it's been reviewed and readopted. If it's been 5 or more years, or if you have no idea.
Looks like everyone's weighed in. The majority at 52% has been 2 or more years. And then a tie at 19% is 1 year. And 5 or more years, and we have 11% at I have no idea.
11%, no idea. Now, assuming that those of you that said, I have no idea, aren't attending this webinar and representing a city, if you don't work for a city, that's okay. If you have no idea, clearly you need to look at it and find out how long it's been. 5+ years, those of you, I think it was what, 19% tie, 1 year and 5 years. So 1 year, 20% of you, 19% of you have done it in the last year. So that's good. 19% of you, it's been 5 or more years. There probably are some things that need to be updated in your personnel policy. Even the 50% that has said it's been 2 or more years, maybe between 2 and 5, there's still a lot that's happened in the last 3 years from a policy standpoint, from a regulatory standpoint, that you need to look at. So we recommend here at MTAS, we recommend 2 years. Every 2 years, you should be looking at your personnel policy and analyzing whether or not there are changes that need to be updated, whether you have accurately captured anything that's occurred in the last couple of years, and that the practices, the things that you're doing, the things that you say you do in your policy and the things you do in your day-to-day environment at your city match. So it's important to look at those things. So with that said, I want to get into why do we even have personnel policies in the city? Well, it's required. Personnel policies, back in 1997, TCA 654-123 was adopted. And it basically says that on or before July 1998, any municipality incorporated before June 13th, 1997, that has not adopted a personnel policy by ordinance, resolution, or otherwise, shall adopt such policy. So the interesting thing there is, if you had one before 1997, there were some legacy permissions that applied, but we're not going to really get into those. But the essence is that every city in Tennessee is required to have a personnel policy. And the statute goes on to say the city or town can work with UT MTAS in cooperation with the Tennessee Municipal League in developing its policy. Now, when this legislation was passed, TML was probably a little bit more heavily involved, but at this point, the vast majority of that type of work rests with us, UT MTAS. And as such, we produce model personnel policies that can be adopted. And incidentally, that's where myself and my colleagues will be for the next couple of days, putting our heads down, working on some updates on your behalf. So the copy of the resolution or ordinance that adopts the policy shall be published in a newspaper of general circulation in the municipality before final adoption. So you have to let people know, you have to communicate that. And then the copy of the personnel policy, as required by this statute, has to be kept in the office of the city recorder or clerk and made available to any employee upon request. There are other means and mechanisms by which you can store this, but it at least has to comply with that. So that said, it also goes on to kind of detail the things that it may contain. Now, when it says may contain, it does not require that you contain all of these things or really any of these things based on that policy. There may be, or based on that statute, there may be other statutes that require certain things, such as the Tennessee Healthy Workplace Act mandates certain harassment policies be in place. But the things that it suggests, hiring procedures, how you hire people, the rules and regulations around those hiring decisions, any benefits, or at least a reference to the benefits. Some cities choose to outline the benefits and reference to plan documents that further describe the benefits, and that's okay. Any personnel rules and regulations, fair and reasonable complaint conferences. I want to pause on that for a second, because there's often a difference in understanding What is a complaint? What is a grievance? And what is an appeal? A complaint or a grievance falls under the category of, for example, if you have someone who needs to discuss a reasonable accommodation under the ADA, if you're covered under that, or a grievance about the application of a management policy or a rule, that's a grievance. An appeal, however, would more generally apply to disciplinary decisions under due process. We're going to discuss that a little bit further on. But again, hearing procedures for employees dismissed, demoted, or suspended if they apply, procedures for compliance with any federal laws, including but not limited to FLSA, ADA, and so forth. And we've had some added to that that you need to document. It may contain your drug and alcohol testing policy. We do recommend, and again, we'll talk about this later on, that maybe you reference it, but detail it in a separate document, adopted maybe differently in some circumstances than your personnel policy, and it may contain a sexual harassment policy. But interesting nuance here. The statute does say that the policy that you adopt may not by itself essentially grant a property right or contract right to the job to any employee. The specific wording says the policy may not grant a property right or contract right to the job to any employee. And what this means is property rights, property interest. In other words, the right to have a hearing before the property of employment is removed from them. The right to employment is removed from them. This hearing has to happen in advance. It can be a simple Loudermill hearing. If you want to, investigate what a Loudermill hearing is, you can look that up. Loudermill versus Cleveland Board of Education was the case. But that establishes how to proceed when there is a property interest. A charter may grant a property interest. Other means and mechanisms may grant property interests. Civil service, adoption, and so forth. But simply the policy itself, based on this statute, may not grant a property right. Again, we'll kind of discuss that a little separately. So, with that said, how many of your cities promise property rights in employment?
While people are voting, I do have a question.
Okay.
It says, do we have to publish in the newspaper every time there is a revision?
That I'm not sure of. I'll need to do a little research. We can get that offline. Heather, if you can document who is curious about that, I can hopefully get back to them soon.
I've got that. I'll take care of it. And based on our poll, 0% said yes.
0%. So 100%
said no.
not grant property rights. Well, that's interesting. I was expecting some, at least, to address to promise property rights, or through an appeals process or a notice of charges. Usually, when property rights are granted, cities usually, and I say usually because they have documented, procedural steps where charges will be presented to the person. They'll have an opportunity to have a free action hearing and then an appeal afterward, potentially. So if you don't have those circumstances, that's interesting. I know several cities do articulate that. So that's good. It gives me some information. All right, so let's talk about how it's adopted or changed by a governing body. So if you're, and I didn't have a poll on this, but think to yourselves, is my personnel policy adopted by ordinance or resolution? If your personnel policy is adopted by ordinance, and that takes 2 readings, public hearing, it has to be changed by ordinance. For example, if you've adopted a policy and you want to change the holidays, you want to add holidays, and you do that by resolution, it doesn't actually change the policy. While you're changing the practice, you need to make sure that any amendments to the policy are performed the same way that it was initially that it was last created. There's a way, obviously, to move from ordinance to resolution or from resolution to ordinance procedurally, but each of those has certain steps to arrive at that destination. But if your personnel policy was created by ordinance, it has to be changed by ordinance. And if it was created by resolution, you can change and amend by resolution. If you need any navigation of that or any questions to that, you can reach out to us. I'll give you at the end, you'll get to see your HR consultant's contact information, or you can reach out to your MTAS general management consultant if you're familiar with those persons. All right, so let's get into the purpose of reviewing. I mean, it's kind of self-explanatory. You want to keep up to date, but as mentioned earlier, you want to review what you do versus what you say. What are the actual practices that are in place? How you treat employees in the context of their day-to-day, how things are dealt with, and review that against what your personnel policy says. It's an instance of not just say what you do, but do what you say. And if you're doing things differently, you need to articulate and document. Policies are, if they're adopted by ordinance, it's tantamount to local law. You have to be accurate. The keeping up to date, that goes back to why we recommend that you review it at least every 2 years. Every year may be doable, may not be doable, but you can typically prepare and review every 2 years. And there are some things in the pipeline that you're going to be or need to be mindful of. For example, the potential change to the Fair Labor Standards Act, salary level for exempt employees. Instead of $684, there's a probability that will increase to $1,059 per week in the coming months to a year. So certain things that affect the employer-employee relationship need to be included. You need to take an annual look at what's changed, or at least a biannual look at what's changed, and update accordingly. So when you get ready to do the update, there are a few things that are important to do. First, you need to gather pieces of information. One of the things that actually the point that you should start, look at your charter. I'm not, again, we don't have a poll for this regarding how many of you are familiar with or have looked at your charter. That's not often a thing that people look at very often, especially in HR. I would get intimately familiar with your charter and what it says about who appoints, promotes, demotes, suspends, terminates employees, how your charter language is constructed, so that you can compare it to your municipal code. Usually your personnel rules and regulations are contained in Title IV of your municipal code. In some circumstances, those rules and regulations are articulated in depth under Title IV. One of the things you need to look at and analyze is whether your charter and your code actually match up and comport to one another. Another thing that you may want to consider is, instead of articulating all of your personnel rules and regulations in Title IV, simplify Title IV to reference the fact that you have an adopted personnel policy by either ordinance or resolution. It is available at the city recorder's or city clerk's office, and leave it at that. That way you don't have to update your code, which can be fairly time consuming and somewhat expensive, actually, because you've got to pay someone, whether it's MTAS or someone else, in most cases, to update your code, to recodify. So moving that out of your city code in detail benefits the city in that you don't have to update that every time you update your personnel policy. So you would gather your charter, gather your code, gather any personnel related ordinances and resolutions that may not have been included yet in your personnel policies. Sometimes that happens. A board may act on a thing and it just hasn't been incorporated yet. Minutes of board action on personnel related things. Can't tell you how many times I've encountered a situation where a city has wanted to move swiftly, so they just take it before the board gavels it, and it actually wasn't adopted by ordinance or resolution, but it signifies an intent to do something differently. That needs to be included in your personnel policy. Gather any plan documents for benefits, for example, your health plan. That informs the elimination periods that need to be included in your personnel policy in regard to when people are eligible for certain benefits. This wouldn't, it may or may not include your voluntary benefits, but definitely the benefits that the city provides for all employees. Gather your most recent classification compensation plan, because that should have information, typically speaks to several things. It may speak to your performance management system in relation to how people are moved up the pay scale. And again, you need to detail this piece in the policy to the extent necessary. Any information on departmental practices that need to be incorporated. Oftentimes, your public safety departments have SOPs. It's a good time to sit down and look at those SOPs and see if there's any conflict with how they've articulated things in comparison to what the personnel policy is intended to grant or constrict. Sometimes there's confusion between the two, and it's an opportunity to clarify those things. So I'm going to pause for a second and see if we have any questions.
Nothing is coming up at the moment.
Okay. All right. Just didn't want to leave that out as an opportunity. All right. So what to include in your personnel policy? We've got a list here, and this is not an all-encompassing list. It's not an exhaustive list, but these are some things that we produce example policies for here at MTAS that can be customized to your purpose. So the purpose of the personnel policy, what it intends to do. This often includes some EEO statements and so forth. The coverage, who is actually covered by the policy. Sometimes it varies from city to city who's covered, whether it's ongoing part-time, covered under certain benefits, or only ongoing full-time, maybe differentiating some benefits for volunteer fire, police reserve, and articulating who is excluded from coverage of the policy, such as elected officials, city attorney, and so forth. And by and large, that's going to be very similar across cities, but there are some nuances that need to be looked at. It needs to articulate who has the authority to administer the policy. And usually what we do is reference back to the charter language that says such and such official is authorized to appoint, promote, suspend, discipline, or the board is authorized to do such. References to class, comp, pay practices, Fair Labor Standards Act. Now this is where you're going to have some variance, especially if you have differences from city to city and compensatory time usage and so forth. but it should provide a fairly detailed description of the basic laws, the EEO laws, Title VI reference at least, Title VII in detail, which protected classes are covered and to what degree, any state laws that may apply, the Americans with Disabilities Act, any emerging acts such as Tennessee Pregnant Workers Fairness Act, Federal Pregnant Workers Fairness Act, the Pump Act, depending on the size of your employer and so forth. Selection, pre-hire processes, so forth and so on. Now, if you go to the second column, there's a reference to drug and alcohol. As I mentioned earlier, having the drug and alcohol policy included in your personnel policy is an option, but usually that's a fairly lengthy policy. You can articulate that you're a drug-free workplace, the expectations of being a drug-free workplace, and then reference to a separately adopted policy that details your drug and alcohol policies and so forth. And then your disciplinary and separations. It's important to have an acknowledgement of receipt that articulates the fact that even if you haven't signed this, if you refuse to sign this, continuing to work for the city indicates acceptance of these terms. So how you actually describe the acknowledgement is important. And again, we've developed, I think, 116 model policies that we can utilize as applicable in your specific circumstance. However, we do recommend in some cases to consider holding some policies, or at least some details of some policies, separate. I mentioned before the specifics of a drug-free workplace. The reason we recommend that, for example, if your personnel policy is adopted by ordinance, your drug-free workplace is included in its entirety in your personnel policy, and the Department of Labor changes the percentage of persons or positions to be tested under US Code 49 for DOT. Let's say they change it from 25% to 50%. And thus you have to make a change to your policy to reflect the amount or the percentage of persons in that position to be tested. Then what happens is you're going to have to readopt your personnel policy to change that language. Same thing with take-home vehicles list. Let's say you add some positions to your take-home vehicles. That means you have to adopt your personnel policy. Your travel ordinance, of course, hopefully you've got a travel ordinance that you've adopted and submitted to the comptroller's office, and according to your ethics policy, your ethics ordinance, oftentimes that's contained in a separate piece of your municipal code. So these four things and some others may be changed occasionally, infrequently, or frequently, but they're either adopted because they're required to be in the case of the travel ordinance and the ethics policy, or subject to changes in regulations like the drug-free workplace policy itself, or just operational needs like the take-home vehicles list. So these things, adopt them possibly separately by resolution, reference it in your personnel ordinance or resolution that we have these policies. We'll give you a general description of these things, and you can find the details as an addendum adopted separately by resolution. That gives you the option or the opportunity to adjust things that may need to be done so more frequently. So let's unpack a little further. I'm not going to spend a lot of time on at will versus due process because we have no one here who's due process, but I'll spend a little time on it. So you can terminate or suspend or reduce the pay of, take away a property-ish, as normally viewed under property interest, for any reason, as long as it's, for good cause, for bad cause, as long as it's not for unlawful cause under at will. I do recommend, if you terminate somebody under at will, that when you fill out your unemployment statement, that you have to give them their separation notice, that you detail that. Don't just put on there, they're at will, I'm firing them, I'm giving them no reason. they will draw unemployment. You have to show some sort of rational basis that you've separated them to protect yourself from having to pay unemployment. Now, to do that, we typically provide a reasonableness standard that articulates how to go through the rational analysis of should the employee have known better? Did the employee know better? Was it communicated in general to employees at large or specifically? We're all similar type situations, fairly treated across all employees. So is it reasonable at this point to terminate somebody? Yeah, if you satisfy those things, and you're fairly defensible in your outcome. So compared to due process, which, if you grant a property interest, we discussed a little in general earlier, you have to have a pre-action hearing and then the opportunity for an appeal. And this can get laborious, time intensive, and somewhat risky. But again, if you need further analysis on either of these circumstances, you can reach out to your MTAS HR consultants. Will help walk you through it. So that said, now let's move on to some roles and responsibilities. Quite simply, the responsibility of your governing body is to legislate. They vote on the policy. It's important to keep them involved, at least in the initial step, and preferably in every step. One way to do this is to start with a work study. I've had several instances occur where, we've been called by a city. City says, "Hey, come help us with our personnel policy." Great, we want to. We'll come help. In a rare subset of situations, there have been instances where the governing body didn't know that the city was actually working on that, and had, I wouldn't say concerns, but would have liked to have been included in that. Now, if you have a work study, keep in mind that it is a public meeting. You have to advertise it, especially if it's going to be a work study. Make sure that you're well prepared in advance. We'll talk a little bit later about the steps to get prepared. But be sure to include the intent of your governing body, because if you make amendments to a personnel policy and don't include them and have to explain to them after the fact, it slows the process down. It increases the risk that the policy itself might not be adopted. So they're important to keep informed. But it's important to align, again, with your charter. I'm just going to briefly touch on the different types of charters here in Tennessee. Private act charter. If you're a private act charter, it applies only to your city. It's adopted through the legislature. It's changed through the legislature. If it's a general law charter, whether it's general law mayor aldermanic or general law manager commission, applies to all cities across the state that have that. You've got metropolitan government, and then home rule charters, which, they're authorized by the Constitution. The status of the charters, change by referendum, and it can remain or be revised. So, last count, we had 212 private act, 116 general law, only 3 metropolitan governments, Nashville Metro, Lynchburg, Moore County, Hartsville, Trousdale County, and then 14 home rules. So just out of curiosity, and also giving us a chance to catch up on some questions in the chat, I'm going to also give you a chance to look at another poll. Do you
have a question?
Okay.
Just to clarify, if our personnel policy references our drug-free policy and we make changes to the drug-free policy, it has to be approved by a resolution?
If the drug-free policy was adopted separately, and it should be adopted in some form or fashion, if it was adopted by resolution, a simple resolution to change it is the best way. So, for example, if your personnel policy is adopted by ordinance and your drug-free policy is referenced in that ordinance, but separately adopted by resolution, you would need to change it by resolution. If it were simply adopted by board action, just take it before the board, say we've changed it because of this, they gavel it. But yes, in any mechanism that something was adopted, that's the appropriate way to amend it. Hope that helps.
We have a few more people voting.
Okay.
This looks like we have 33% as a private act, 25% general law, 0 metropolitan, 4% home rule, 21% doesn't apply to me, and 17% I don't know.
Okay. Not unsurprising, especially based on the numbers of how many private act charters we have in Tennessee. Is the majority of charters in Tennessee are still private act. You can adopt in the private act certain things that look like a general law charter. You just got to be careful in doing so. So that's interesting. Now, the don't know, 17% also doesn't surprise me. I would recommend that you find out what type of charter you have, because that's going to inform how you approach and construct your personnel policy to some degree, because that charter, if it's a private act, will detail, well, on varying degrees and varying levels, how you approach such an issue. If it's general law, it's standard. You pretty much know who does what. But those of you that have those private act charters, do a little digging. And those of you that don't know, find out. The 21% that doesn't apply to you, I'm assuming that you work for a utility district or a county or somewhere else. All right. So moving on, I want to unpack a little bit some of the acts that apply to you based on how many people work in your cities. If you have one person, these acts apply. Fair Labor Standards Act, Equal Pay Act, Fair Credit Reporting Act, USERRA, Tennessee Guard and Reserve League. I just want to highlight a few differences in USERRA and Tennessee Guard and Reservist Leave. USERRA is essentially where someone who gets called up, it protects service members and veterans' civilian employment rights, requires employers to put individuals back to work in their civilian jobs after military service. It usually applies to a call up. Sometimes gets confused with Tennessee Guard Reserve Leave, where if a member, from day one of employment for an employer with one, any officer and employee of the state or any subdivision, municipality, has the right to protected, paid job leave for training and so forth, up to 20 working days in one calendar year. There was a point in time where it was viewed as 28-hour days. It is 20 working days in that calendar year at their usual shift. It's 10-hour shifts, 12-hour, 24 hours. But it does have to be a shift that they were scheduled for, not on their regular day off. So if you need help navigating between those two, give us a call. If you have 8 employees and fewer than 15, you're covered by TCA 850-103, Employment of the Disabled. It's part of the Tennessee Disability Act and Tennessee Human Rights Act. It basically says that you can't discriminate against someone because they're disabled. It does not require that you engage in the interactive process. That's not a requirement until you have 15 employees under the Americans with Disabilities Act, and also the Pregnant Workers Fairness Acts. So if you have between 8 and 14 employees, and when I say employees, it's people other than your elected officials or appointed board members that are paid by W-2s, people that are actually employed by your organization. And, if you have 11 people, you only have to make sure that you don't discriminate in the hiring, firing, and other terms and conditions of employment based on disability. Once you get to 15, however, the Americans with Disabilities Act and the Tennessee and Federal Pregnant Workers Fairness Acts do apply to you. as do the Title VII of the Civil Rights Act and Genetic Information Non-Discrimination Act, GINA. I'm not going to talk in detail about those. They've been around for a while. ADA's been around for a while, but relatively new to us, the Tennessee and federal Credit Workers Fairness Act. The Tennessee preceded the federal by a couple of years. They're almost the same. There's a distinction between the ADA and the Pregnant Workers Fairness Act. So under the ADA, if an employer has for example, two accommodations that are deemed reasonable, and one of those is just placing an employee on leave, it can, in certain circumstances, be justified under the ADA. It needs more scrutiny under the Pregnant Workers Fairness Acts because you can't force a pregnant worker to take leave if another reasonable accommodation is available. So you're going to have to do a little bit more analysis on those cases. Once you get to 20, the Age Discrimination in Employment Act and COBRA, Consolidated Omnibus Benefits Reconciliation Acts, apply. And once you get to 50, these are the things that cover or provide eligibility for your employees. So any public sector employer, any government entity is a covered employer under the Family Medical Leave Act. Now, that does not mean that all of your employees are entitled to take leave. So for them to be entitled to the leave, they have to be an eligible employee. An eligible employee is a person who works for a covered employer, which they do, has worked for the employer for at least 12 months. Those 12 months could be over 7 years. For example, if someone works 6 months 3 years ago, quits, comes back, works 6 months this year, they've checked off that 12-month box. Has at least 1,250 hours of service for the employer during the 12-month period that immediately precedes the need to leave. But here's the kicker, and works at a location where the employer has at least 50 employees within 75 miles. So if you do not have 50 employees, they are not eligible. You can grant them eligibility. You can give more than the law requires, but if you choose to grant FMLA eligibility to someone, you have to follow all of the steps, all of the compliance steps as far as designation, notification, designation, certification, and so forth. So it's up to you whether you do. I'm not going to tell you what to choose, but there are risks involved in doing, let's just say, no good deed goes unpunished in certain circumstances.
I have a couple questions.
Yes.
The first is pertaining to this topic we're on right now, and it says, are volunteer firemen included in this number?
Volunteers are not employees if they're truly volunteers and only given a de minimis stipend in exchange, well, not in exchange, but to defray expenses for their convenience. So if you give someone $35 a call, they're classified as a volunteer. They're not counted as an employee. They're purely a volunteer, even though they've been given a de minimis stipend for their trouble.
All right, then we're going back a little bit because I missed this one. Apologies to Mark. If a personnel policy outlines an appeals process for demotion, suspension, or termination, doesn't that imply a property right? The appeals panel may overturn any of the above. Doesn't that dilute the at-will statements also outlined in the policy?
So that's an interesting question, and I'm going to refer back to a situation out of Cleveland, Tennessee, Keller versus Castile. There was a firefighter who was terminated. There were two pieces to this case, and I would encourage you to look it up. The first question of the case was if the policy grants in one hand a property interest, but claims in the other hand an at-will status, which outweighs the other. Before this case, it was always viewed that you can't give with one hand and take away with the other. But the Tennessee State Supreme Court ruled that in the Keller versus Castile case, if you say you're at will, it trumps your promise of property interest. The second question wasn't addressed, and that was because the city manager in this case was both the deciding party and the appellate level for the disciplinary process, the termination, the appeal process, since that was rendered moot because there's no need to answer that question because it was determined that she had the right to terminate at will because she gave notice. So that's a critical case that actually offers a little bit more protection to cities than they have experienced, at least in their minds in the past. I would, however, if you say at will, don't have an appeals process. Use the reasonableness standard, apply the reasonableness standard and articulate a reason that you're giving someone separation notice. The only appeal at that point would be to, in most cases, Chancery Court, and Chancery Court's going to come back and say, did you follow your policy? Yes or no? So that's typically the avenue that makes the most sense if you want to kind of weigh those two. I hope that answered your question. All right. So picking back up family medical leave, we're not going to really spend time on the Patient Protection for Affordable Care Act, but the PUMP Act, that's part of the Fair Labor Standards Act. The FLSA has a component in there now where if you have 50 or more employees and, you have a person who needs to pump breast milk, you have to provide them certain protections, give them a private space, break time, combine some break times. So you need to have a PUMP Act policy. And that, I think that came about December 29th, 2022. So, that would be something to definitely look at to include in your next update and as soon as you can, articulate that protection. Also, there's usually some confusion around maternity and paternity leave. It's not required by state law yet to give anyone maternity or paternity leave outside of FMLA until employers have 100 or more employees. So the interesting dynamic here is this is a state law, FMLA is a federal law. I'll give you an example. January 1, I take 12 weeks of FMLA because I'm caring for a dependent who has a significant illness, and I take my block leave. I take off my 12 weeks of block leave. Later in the year, I'm adopting, or my wife will give birth. I still have those up to 4 months. It's not 16 weeks, but it's articulated in 421-408 as 4 months for adoption of protection under the unpaid leave. So you're going to have to, it's kind of like the old math we learned in high school, PEMDAS, parenthesis, exponents, multiplication, so forth. The order of operations is important. Did they exhaust a certain leave under the federal only and then are covered and eligible under the state? Or did maternity happen simultaneously? So if someone has not used any FMLA and they're eligible for FMLA and Tennessee maternity, paternity, if the first event was an adoption or a birth and they take 4 months off, they have simultaneously exhausted their FMLA and their Tennessee maternity, paternity. So just a little caution about how those things interplay with one another, and also how those things can be confused a little bit. All right. So I want to mention a couple of things that have happened in the last 2-3 years. So here are some acts that you may want to be familiar with that have occurred since 2021. We got a couple dealing with self-funded insurance plans, some dealing with TCRS, COBRA coverage, reimbursement. Chapter 470 is one that needs to be articulated in your policy if it's not already included. Some have the language already that makes it clear that if you're arrested, the charges are dropped, you're found not guilty, and you return to work, you're given back pay. But this formalizes it, requires that circumstance to be covered. Chapter 478, the salary supplements for volunteer firefighters. You need to include that. retired law enforcement officers, how that interplays with them coming to work for you after they've retired. Just take a look at those circumstances. You may or may not need to articulate that in your specific personnel policy. Some from 2022, 1922. Some of these sound like they're that old. Residency requirements for certain first responders prohibited. So that's chapter 720. Amends TCA 850-107. I would look that up. First responders, a paid full-time law enforcement officer, firefighter, EMS personnel, or dispatcher of law enforcement, fire, or EMS, but not the chief or the head of the department. So what this also excludes Hamilton County for the prohibition. So it's got a little slot in there for a prohibition, but it requires that cities no longer enforce or have residency requirements for these positions. I know several cities in the past have said you have to live within 30 miles to work here, or within the city or the greater planning region for these personnel. We can talk about, rather than a geographic requirement, that there be a response time requirement, and kind of look at those. So you can give us a call if you need to wade through that.
May I interrupt? We have another question, and it's regarding FMLA.
Sure.
So if someone has exhausted their FMLA earlier in a rolling calendar year, but then needs to take FMLA for maternity, paternity, they can take an additional 4 months.
Yeah, and that depends on what they exhausted their FMLA for. If they exhausted their FMLA for maternity, paternity, they are not eligible. They don't have anything left, right? Except for maybe 4 weeks or 1 month, depending on how much FMLA was exhausted. Let's say if someone takes 8 weeks under FMLA, they should be also reducing their leave under Tennessee maternity, paternity leave. But if someone takes FMLA to care for a sick spouse, they're not exhausting their Tennessee maternity, paternity leave. It's still intact. It's still available to them, and they're still eligible to take it. So that's why it's important to look at the context of when a law, how a law was created, who created it, and who regulates it. So the federal requires FMLA for certain things, and it allows FMLA for more things than maternity, paternity. So you have an availability to use that for things outside of maternity. If you use it up outside of maternity, you still have your maternity leave under state law. Hope that clarifies it. Oh yeah, I'm looking at the chat. I can see abuse of time here. Yeah, and you've got to. That's why it's really important to stay on top of FMLA use, follow the certification processes, follow the processes that support the use of TMLA. So
I have another question on that. So you are not required to take FMLA for maternity?
oh yes, you are. Let me clarify. If what you're taking leave for is a qualifying event under FMLA, it has to be exhausted and worked down. If that event connects to both leaves, then you exhaust both leaves simultaneously under FMLA and Tennessee maternity leave. What I'm talking about is if you exhaust FMLA under something outside of maternity, paternity leave, if it's something not related to medical condition, or, give you an example, if January 1, I had to have a limb reattached and I'm out for 12 weeks, but later in that year, in October, I'm going to give birth to a child. I have used my 12 weeks under FMLA to have my limb reattached. I have not used my 4 months under Tennessee maternity leave to give birth to a child. I still have that available. I know it can be a little bit confusing and a lot to take in, especially on a webinar, but again, if you need to work through these situations offline, give us a call. That's what we're here for, to help you.
I have another on the maternity paternity issue. It says you have an employee that is due to give birth before eligible for FMLA. say only employed 10 months, but meets the 12-month employment requirement for FMLA while out for the birth of the child. Can they request additional 12 weeks under FMLA?
Okay. We've only got 5 minutes left in the webinar, and I know we could get off on a big FMLA specific situation tangent. So again, I'm going to ask that we table these FMLA questions. We can reach out. We can make sure I'll actually be together with the other two HR consultants today, and we can find out who that comes from and get back to one of you to work through. Okay.
One more question.
Okay.
As it comes to the number of employees for these laws, we have several seasonal employees that work a few months during the summer only. Are they included in the 100 needed employees for these laws?
I have to look to make sure. There's a bunch of different law circumstances and headcount circumstances, but typically if you have X number of employees for 20 or more weeks in the current or previous calendar year, your headcount is above that number, you are covered by that law. Okay. All right. So we've covered a lot of information here. We've got a few minutes to wrap up to be considerate of everyone's time. I want to talk about the steps you need to take. When you get ready to amend your personnel policies or update them, first step is to research the last update. Find out what you did and when you did it, and all of the things that feed into it, all of the little connecting dots that fed into it or likely to feed into the next one. Discuss the need to update with your chief administrative or chief executive officer and your governing body. Have a plan that you can talk to them about and describe where you're at, where you're needing to go, and how you get there. So put together that action plan, gather all the needed materials. And at that point, that's a good time to talk to your MTAS management consultant about the direction you're heading, or anytime in steps 1 through 4. Reach out to us and we can advise on how to best navigate any of these steps. But if you're comfortable on steps 1 through 4, you've gathered the needed materials, you're ready to engage in the update, talk to either your management consultant, reach out to your HR consultants, and then schedule a meeting with us and your staff. If the staff is the group that the council wants to work on it, or if they want to be involved, set up a work study where we come and work through each of the steps, the changes, and so forth. Now, it's definitely going to necessitate a work study if you have to change any charter language before changing your personnel policy. For example, if you want to change it from the mayor to the city administrator and your charter doesn't contemplate that, you're going to have to go through a charter change before you update your policy. If you don't have anything that complex, it can move fairly quickly, but sometimes it moves slowly. It may be done in just a few meetings. It may take 3, 6, 12 months to navigate, especially if there's a lot of detail, a lot of change that needs to be made, and a lot of things that need to be met on by the governing body before they can take it to council for adoption. So to speed up that whole process, research the last update, have a discussion, put together an action plan and a timeline, gather the needed materials, all of the needed materials that we talked about earlier, and then kick it off. Okay. But who do you call? When you're ready, if you're in East Tennessee, call Betsy Cunningham, email Betsy. She is your East Tennessee HR consultant. If you're in West Tennessee, Peter Voss, email Peter. He's your West Tennessee HR consultant. If you're here in Middle Tennessee, give me a call, shoot me an email, and we'll get to work on that for you. With that said, I would like to thank all of you for attending. Thank Public Entity Partners for allowing us to spend some time with you.
Well, and I want to thank you, John, for all the great information and for everything you shared with us today. I know everybody has lots of questions, and your MTAS consultants are always available. Just contact them if you have more questions. And thank you for joining us for our Partnering for Success webinar series. The next webinar will be announced soon. Watch our website and your email for more information. Thank you guys again, and thank you for your participation in Public Entity Partners, and we hope you have a great afternoon.
And I want to thank you all for some good, challenging questions. You tested my ability to think on the fly a little bit here. And again, if some of these things are still weighing on you, reach out to us.
Thanks again. Have a good day.